Good evening, everyone. We will start in 1 minute. Good evening, everyone. Welcome to tonight's webinar. My name is Robert Lewis, and this is Lishan Jiangtang. And we are presenting this webinar tonight in cooperation with SIPAC, and we're very pleased this evening to have Klaas van der Graaf of the BUREN law firm in the Netherlands. And Klaas, until recently, was the General Counsel for Tesla in the Benelux countries. And tonight he will be sharing with us his experience in the EV market and as General Counsel in a leading EV company. So Klaas, perhaps you can give a brief further introduction to yourself and then proceed with your presentation. We look forward to learning from you this evening.
Thank you, Robert, and thank you for this kind introduction. My name is Klaas van der Graaf, and I'm a lawyer and BUREN partner. And partner at BUREN, heading the automotive practice group of the firm. I specialize in commercial contracting, including e-commerce, commercial litigation, and regulatory compliance and discussions with regulators. I'm a specialist in the automotive sector, and I'm representing clients throughout the automotive value chain. Before joining BUREN, as you correctly mentioned, Robert, I was a general counsel for Tesla in the Benelux area. In this capacity, I was responsible for all legal matters in the region, including distance selling, B2B contracting, regulatory compliance and discussions with regulators, and litigation matters. I worked from Tesla's EMEA headquarters in Amsterdam. I first want to tell you something about our automotive team at BUREN. This team understands the challenges automotive companies face when establishing and building out their business in EMEA. Whether it's choosing and executing on an appropriate sales model, navigating a complex legal framework consisting of national and EU rules relating to homologation, road and product safety, consumer law, data protection law, advertising law, or other topics, supervision by regulatory authorities, international contracting, product litigation, labor laws, or other topics, our team can support you. We are uniquely positioned in the Dutch market due to a combination of deep knowledge of the applicable laws and regulations, specific automotive sector expertise, and a pragmatic and cost-effective approach. I've included a slide containing a selection of BUREN's automotive-related experience and clients. One of the key advantages of BUREN compared to other Dutch law firms is that we have a dedicated China practice group with significant experience servicing Chinese clients and helping them establishing and expanding their business in the Netherlands. The China practice group incorporates knowledge of the Dutch and legal and Chinese laws and regulations, culture, language, and business traditions. What is relevant is that we have offices in Beijing and Shanghai, and lawyers that are fluent in Chinese, Dutch, and English, so we are able to bridge the gap between cultures and legal systems. Now, I've also included a few slides with a selection of our Chinese clients throughout industries. And as you will be able to see, these contain both listed and non-listed large Chinese companies. Now, with this introduction out of the way, we have selected a few topics to discuss with you today. Firstly, I will be discussing the most common sales models of automotive companies in EMEA and key attributes of those models. Secondly, I will discuss advertising, specifically from an automotive perspective. After that, I will give you some practical takeaways in regards to supervision by regulatory authorities, and I will close off by touching upon the litigation landscape in the Netherlands and a few practical points for your consideration. There will be room to ask questions at the end of the presentation if you want this. And a terminological point, I will regularly refer to automotive manufacturers in this presentation as OEMs, or original equipment manufacturers. So starting with the sales models. Obviously, the choice for a certain sales model is very determinative for how the business operates and the type of legal and organizational risk that needs to be considered and managed. There are essentially three sales models that can be considered by an OEM. These are distribution, agency, and e-commerce. And obviously, there are also dual distribution variants that I will not be discussing today, but those are also possible. In a distribution model, an OEM sells vehicles to an independent distribution partner in a local market. This distribution partner then resells the vehicles on the local market in its own name and for its own account. And what is relevant is that this is traditionally the dominant sales model in automotive. OEMs don't sell vehicles directly to end customers in this model, but to importers and independent dealer associations. A distribution model is also the sales model applied mostly by legacy automakers, such as the German automakers and the American ones, and also, for instance, at the moment, by Chinese manufacturer BYD in the Netherlands, which sells its cars through Lauman Group, one of the major importers. A distribution model definitely has its advantages. The distribution partner typically has a physical presence, has significant knowledge of the local market and applicable rules and regulations, and can take care of sales and after-sales activities. However, distribution agreements between OEMs and distribution partners are subject to EU competition laws. Amongst other things, it follows from EU competition laws that an OEM can never set the minimum prices a distribution partner can apply towards end customers. As a result, pricing can become intransparent because distributors can apply different pricing throughout the region. So, for instance, you will never pay the same price for a new BMW in various Dutch dealerships. In addition, it can be difficult to set up a direct-to-consumer sales model in parallel to a distribution model for this reason. Distribution agreements typically contain, for instance, clauses on exclusivity or selectiveness, inventory and minimum volume commitments, commitments on advertising budget, and other market-specific investments by the OEM and the distribution partner, reporting by the distribution partner on his activities, commitments on after-sales activities, and other topics. So far the distribution model I want to cover with you today is the agency sales model. In an agency model, the OEM sells vehicles directly to end customers, but appoints an agent to act as a local intermediary to negotiate and conclude these agreements in exchange for a commission. The advantage of an agency model compared to a distribution model is that EU competition law does not apply in such relationships. The OEM gets to determine minimum sales prices and can determine the agent's geographic sales area and customer groups without limitation. However, a genuine agent may not assume economic risk in relation to transactions with end users. He may not be a de facto reseller, have a large inventory, etc. The OEM must make the market-specific investment such as investments in the sales premises and in advertising for the local market. Now, in terms of trends and developments, in the past couple of years, we have seen legacy OEMs attempt to steer away from a distribution model more towards an agency model. An example of this is Ford, which announced it would switch to an agency model in the Netherlands in 2023. However, from what we have heard from voices in the industry, these transitions have so far not been very successful. The reason is that the traditional automotive value chain is geared very much towards distribution and less so towards agency. Switching to an agency model when you already have a distribution model may be more difficult than immediately setting up an agency model, because you can make a comprehensive set of arrangements from the offset and avoid transitional issues related to, for instance, market-specific investments. And I think one of the takeaways from this is that it underpins the need to identify and execute on an appropriate sales model from the very beginning. The third and final sales model I want to cover with you today is the e-commerce model. In this model, the OEM sells the goods online directly to end users. A lot of new market participants choose this sales model. Examples include Tesla, which I think was the first OEM to do this, but also many Chinese OEMs such as Zeekr, XPeng, and NIO in the Netherlands, for example. OEMs in a direct-to-consumer sales model are responsible for after-sales activities, including service, complaints, and litigation. An advantage of an e-commerce model is that it cuts out the middleman, so you have better gross margins. But what you should keep into consideration is that distance selling is a highly regulated activity based on EU distance selling and consumer law implemented into local state law. And OEMs conducting distance sales must ensure their website is fully compliant. And also their apps, for instance, if they sell through apps. This includes, amongst other things, disclosing a specific set of mandatory information in the correct place in the customer's online sales journey, providing agreements in the correct manner and also on a durable medium, and having a correct order button in the online webshop, for example. Now, from a practical perspective, it is important to note that these rules are very strict, and they can have harsh consequences if they are not observed, particularly by automotive companies due to the high unit prices. For instance, courts will deduct up to 50% of the purchase price if a trader does not disclose all essential pre-contractual information in the online sales journey. Consumer authorities can levy high fines and penalties. The 14-day cooling off period can be extended by a full year, and the ability to deduct for usage can be compromised for these returns. These are very real risks that need to be addressed when distance selling cars at scale. And based on past experiences at Tesla, I would strongly encourage having the online sales journey thoroughly reviewed from a legal perspective and making sure that all the appropriate boxes are ticked. A lot of companies, also the established ones, make mistakes in this regard and face the consequences. And consumer groups are also actively attempting to exploit these mistakes. And I've included an example in the slides of a consumer association who is actively suing 17 large corporations for reimbursement of the purchase price in relation to violations or alleged violations of their duty to inform customers. So this is something that has to be taken very seriously. I want to close off this topic by mentioning that consumers ordering goods and services online in the EU also have a right to withdraw from their purchases within 14 days after taking delivery. And that occurs in principle against the full refund. And this is also referred to as the cooling off period. And a consumer does not need to provide any reasons for returning the product. This only applies to B2C sales and not to B2B. Your counterparts in the business will typically dislike this very much, and sales teams need to be trained to properly process these cases. In some markets, not performing the refund in a timely manner can lead to significant penalties. For instance, this is the case in France. The cooling off period is something to consider in relation to auto sales, where registration can already cause depreciation. There are limited exceptions, and I have a few on the slides. One of the things you could consider is that you could argue that in the case that there was a prior test drive, a customer has not ordered exclusively through means of distance communication. And there are some indications, for instance, in German case law, that you can exempt those types of orders because they're not ordered exclusively through means of distance selling. So if a customer has taken a test drive, this right does not apply. This is arguable. You can deduct for excessive usage and potentially, but that's more subject to debate and not crystallizing case law, you can deduct the loss of value as a result of registration, because registration is also something you cannot do in a traditional brick and mortar shop. But in any case, it is not advisable to mention the possibility of deductions in the withdrawal instructions, because you do not want to limit the consumer's right to withdraw in the withdrawal instructions in any way. That's very risky because it can lead to a 1-year extension of that withdrawal period. So that's not something you want to do. So I hope this, and you're definitely going to be dealing with this 14-day cancellation right if you are doing e-commerce with autos in the Netherlands. There are a lot more nuances to this, and yeah, we're obviously available to discuss these with you. But for now, I want to move on to the second topic, and that is advertising in the automotive sector. And rules related to this are transposed into local state law from EU directives. Advertising laws govern the relationship between the advertiser and the consumer, but also, for instance, the relationship between competitors. Advertising is defined broadly and also covers, for instance, the contents of a website. Two main requirements that need to be considered when advertising are, and the first one is, are advertising statements factually accurate? So, for instance, the acceleration, the battery capacity, etc. And the second, are these advertising statements potentially misleading? So, for instance, if you include the gas savings in the list price that you're mentioning, that can potentially be considered as misleading. Comparing products with products of competitors is in principle permissible, but you need to consider a few rules, which I will not be covering in this presentation, because I want to discuss a few automotive-related items in relation to advertising. The first, and maybe obvious one, is that advertised pricing should be all-in pricing. So it should include all unavoidable costs, such as delivery readiness fees, but also, for instance, VAT. And as I mentioned, you cannot include gas savings in advertised pricing because that's potentially misleading. Now, do you include government incentives and subsidies, which is obviously also very relevant in the EV market? That depends on the incentive structure, which will vary from market to market. But I think it's typically tricky to include this in the trim price. There are some markets where that's not the case. For instance, I know that it's been done in France, for instance. Another relevant point in advertising is our range disclosures. So obviously it's something consumers pay a lot of attention to. And they will also frequently make complaints or even initiate litigation in relation to a vehicle not reaching its advertised range. An example is a recent case we've had in the Netherlands relating to a Jaguar E-Pace, which had a WLTP range of 450 kilometers, but only reached an actual range of less than 300 kilometers. And the Court of Appeal, so the court in that case, awarded a non-conformity claim by the consumer related to this discrepancy. although this is still subject to review by the Dutch Supreme Court. And what is the takeaway from this, which you can apply in practice, is that it's highly recommendable to make it very clear in, for instance, your online configurator, if you have an e-commerce model, which benchmark is being used to determine the advertised range. So for instance, WLTP range, and that this benchmark does not guarantee any actual range, because an actual range obviously depends on a number of variables. For instance, the temperature, the driving style of the driver, and the terrain in which the vehicle is being driven. So you cannot, and you should make it clear that you do not guarantee any actual range. And the third thing that's very relevant for automotive advertising are green claims. So obviously, electric vehicles, they have very low scope 3 emissions. And it is okay to point that out in your advertising by making a comparison to traditional vehicles. But you should be very mindful of the fact that these green claims are heavily scrutinized, both by private interest groups, but also by consumer authorities. And competitors can also initiate litigation for misleading green claims. So you should always make sure that green claims are factually correct. That's the first thing, but also properly substantiated by underlying materials. And in fact, I would recommend always running these green claims past legal counsel prior to their use, because they're extremely highly scrutinized. The fourth, which I will not really dig into, but I want to mention here, is that financial schemes, so leasing, constructions, and loans, are also highly regulated. And I would recommend always having those checked by a specialized lawyer, because there are some mandatory disclosures relating to those. Again, if you are in doubt, you can always reach out to our team. Then I want to move on to the third topic, which is the supervision by regulatory authorities. Specifically, I want to touch upon the supervision by the Consumer Authority, Road Traffic Authority. And the Consumer Authority, or as I shall call it, the ACM, is responsible for enforcement of rules of competition law and unfair market practices and consumer law. The ACM publishes annual guidelines on how the ACM intends to enforce. 2024 focus points are promoting an open and fair digital economy. So that's, for instance, the platform compliance that I was already previously talking about, and helping the transition to sustainable energy and the transition to a more sustainable economy. So that's, for instance, the green claims that I also already talked about. Typically in practice, for unfair market practices, the ACM sends a warning letter first, including a term within which something, for instance, a contractual provision or an advertisement, must be changed before it takes any actual steps, so warnings or penalties, for instance. There is a possibility of dawn raids, where the ACM visits the premises and makes requests for information. And generally, an OEM must comply with such information requests, which can be quite broad, and an OEM should not obstruct the ACM in performing its activities. It is, however, possible in practice to liaise on the scope of the investigation, process, and timelines for providing follow-up information. It is recommendable to set up an internal task force and make sure outside counsel is involved, also because they typically have the contact with the ACM. Our experience is that once your company is in scope, the ACM does not let go and keeps asking questions until it is completely satisfied. So this can be very burdensome, these processes. The ACM has the possibility of levying substantial fines, and especially does this in practice in relation to repeated offenses. Now I've mentioned the slides, the fines on the slides. So the second regulator I wanted to discuss is the RDW. And the RDW is the Road Traffic Authority. It serves as the regulatory type approval authority and also has a market surveillance function. These are separate functions that are performed by separate departments within the RDW. So there's different individuals involved. Today, I want to touch with you upon the surveillance side. A manufacturer in the EU has a responsibility to ensure the products it brings to market are safe. This safety is assumed if products are regulatory type approved, which is obviously the case with electric vehicles before they are brought to market. The manufacturer must report safety critical defects proactively to the RDW. In case of safety defects, the manufacturer must inform customers and issue a recall. RDW will include these recalls in its online register and can issue a RAPEX notification to notify other EU road traffic authorities. So this is notifications at the initiative of the OEM, but road traffic authorities will also regularly perform investigations based on customer complaints. From a practical standpoint, it deserves recommendation to always ask for the legal basis of such investigations. RDW can be interested in events leading up to single incidents, particularly in the case of severe crashes, for instance. But an OEM is also obligated to register customer complaints, so it may also be expected to be able to respond with, for instance, fleet performance data, where the RDW has received multiple complaints about a specific vehicle part. So it is good to involve your technical experts when the RDW is conducting such an investigation. Written correspondence, that's a practical note, can be requested for by third parties and then in principle must be provided by the RDW. And this means that it can be preferential in practice to invite the RDW over to discuss findings during a physical meeting instead of sending emails and attaching all kinds of sensitive documents, which will then later need to be excluded if a third party request is being made. So finally, I want to touch upon the Data Privacy Authority. The Data Protection Authority surveys compliance with the GDPR and the Data Act. And the Data Act will be applicable as of September 2025. Data Protection Authority has the power to levy substantial fines for infringement of GDPR. And these fines can be very high. For instance, Meta received a fine of 1.2 billion for GDPR violations in Ireland in 2023. And from a practical point of view, it's generally advisable to have customers agree to a privacy policy, outlining their rights as data subjects in the context of the online sales process, and to ensure product, services, and processes are designed with a view of achieving GDPR compliance. So this is a concept that is referred to as privacy by design. An affirmative opt-in is required in relation to email marketing. Data subjects have a right to access their personal data and the right to be forgotten, amongst other rights. The Data Act also prescribes, and this is very relevant for automotive, that users should have access to data generated through the use of the product. And this includes machine-to-machine data, which does not necessarily qualify, obviously, as personal data. Now, this data can be stored locally in the EU. For instance, Tencent does this. But if you want to store personal data from the EU in China, you have to take additional measures. So, for instance, you would have to put in place standard contractual clauses. And there are also other possibilities. What is very relevant for you, I think, is that law enforcement authorities, so essentially the police, will start making a lot of requests once they notice that you have access to certain data. So if they know you have access to camera footage or location data, they will start making a lot of requests for those. And the first response to these requests from a data privacy perspective should always be that the authorities need to prove that they have made a request based on a statutory legal basis. Because otherwise you are on the hook if you cooperate in relation to the Data Protection Authority. So you need to cover yourself there. Law enforcement agencies may need considerable coaching also on the data that is being collected by you. And it's good to have a process in place for how your company handles these types of requests. So this concludes my remarks on regulatory supervision. And now I want to close off on a few items related to litigation, which is obviously an unfortunate fact of life for OEMs. And I want to touch upon individual warranty cases and group actions. I will not touch upon manufacturer's liability for tort, although this is obviously also potentially a relevant subject, but maybe that's something for another time. So first of all, warranty claims. Warranty claims are common, and they typically have a low monetary claim value on a per case basis. And what this means is that this requires a pragmatic approach. And essentially, you could choose to offer customers a lot of goodwill to reach settlements. And specifically at the beginning of a growth journey, you can consider doing this to maximize your customer satisfaction and just improve the quality of your brand. However, and you will discover this when you do a lot of business, sometimes these customer claims tend to get very opportunistic, and they are covered by legal aid insurance, and they just try to initiate claims to get something out of this. And settling the cases can also set a bad precedent because customers will share experience online and start expecting a generous treatment of goodwill cases. So it also sets the expectations in a certain way. At Tesla, we had a business resolutions team between the service and the legal team, who were the first responders to customer complaints and escalated to legal if necessary. And Tesla took the position to fight back on opportunistic and bad faith claims. And what is, I think, a practical takeaway is that outside counsel can effectively decrease the organizational burden by stepping in and creating a buffer between the customer and the business. And this can be very helpful if you have very difficult customer. Then in regards to substance, there are two types of warranty. The first type, which you obviously all know, is the manufacturer's warranty, which for the vehicle is typically a number of miles and a number of years, whichever comes first. And in addition to this, customers can be eligible for warranty pursuant to applicable law. And this is called statutory warranty. Often, statutory warranty is invoked by customers when the manufacturer's warranty has expired. So they actually try to use it to get an additional warranty. And the question is, if there was a defect present at the time of delivery, which is the case if the vehicle did not have the correct characteristics the customer could reasonably expect. And this statutory warranty cannot be excluded for B2C sales, but it can be, and I think it probably should be, excluded for all B2B sales. But if you want to do this, then you should do it on the basis of a clear contractual provision, because if you do not write this down in a clear manner, then it's not going to be enforceable in court. So this is something to consider. The second type of cases are what I will refer to as mass claims. These are actions brought by claim vehicles representing groups of customers. The stakes with this type of claims are typically high, and the publicity is high as well. You typically want to defend yourself with as much legal arguments as possible and adopt a strategy to delay the proceedings as much as possible. And what we see in terms of trends is that there are many mass claims in relation to GDPR violations, and also competition follow-on claims are on the rise in the Netherlands. And generally speaking, the Netherlands has emerged as a popular hub for such claims. And also in the automotive sector, we've seen a number of class actions. So I think probably the most famous one is the diesel emissions claims that are raised against Volkswagen, but also other German OEMs. We have a civil follow-on action in the trucks cartel. And I've also included a class action that was raised against Tesla, which was dismissed in relation to various quality-related concerns. And I think this last one is also relevant, and I already mentioned this, is a class action by a foundation which is invoking violations of the duty to inform consumers in the context of e-commerce. So again, it's a real need to enable to make sure you are compliant in that regard. Finally, I want to discuss a few litigation clauses for you to consider and which you can potentially use in your business. So arbitration clauses, yes, you can use those in a B2B setting. So also in your order agreement for the vehicle, but you cannot do it for B2C customers. And for a forum clause, so saying that a customer needs to litigate a case in a certain market, this can also be done for B2B customers, but it cannot be done for B2C customers. And from a practical perspective, you could really consider using this because some legal systems in Europe are less developed than others. So by including a forum clause, you ensure that your disputes, at least in regards to B2B customers, are being litigated in markets where there's a sophisticated legal system with predictable outcomes. And I think that's a very important one. Also, it disincentivizes, at the end of the day, customers to litigate small claims. For instance, if you're an Italian company and you have a 3,000 euro claim, and you have to litigate that claim in the Netherlands, you're going to be disincentivized to actually do that. So this can really be considered. A choice of law clause, yes, you can do that for B2B customers. For B2C, you can also do it, but you cannot limit or deviate from statutory consumer rights. What I would definitely recommend you do is exclude participation in the European Union's online dispute resolution scheme, which you need to do in your contract, and also explicitly exclude the Vienna Convention for the international sale of goods, because that's also something you do not want to have govern your contractual relationship. So this is what I wanted to give you in terms of the litigation landscape. And also more generally, this was the presentation. So thank you. Obviously, yeah, I built in some room for questions, but I don't know if that's allowed for in this forum. Robert,
yes,
maybe you can fill me in on that.
Yes, actually, we've been collecting questions during the course of your presentation, and I have some questions.
Oh, great.
I'm going to start with the big question, which was not included in the scope of your presentation, but all Chinese EV manufacturers or OEMs are aware of the anti-subsidy investigations that are ongoing.
Yeah,
do you have any comments on the status or the progress of that, or what's behind that and what the anticipated outcomes may be?
I think generally speaking, this is something that is drawing a lot of public scrutiny. We are seeing it a lot in the Dutch press and also the international press. And I think, what is clearly the case is that in Europe, we are getting concerned about protecting our domestic automotive industry because it simply cannot compete with how the Chinese manufacturers are doing. Energy is more expensive here, labor is more expensive here. So we're getting outcompeted basically on every angle. And this leads indeed to a lot of voices, or at least an increasing amount of voices that are concerned about that and want to take more protective measure. I cannot really exclude that this is ultimately going to happen in the future, but at the end of the day, we also have the European elections coming up. I think those are in June. These may make it more difficult for European legislature to adopt effective regulation to actually address this. I'm not too concerned that something is going to happen in the near future, but it's obvious. It is very clearly a topic here. That's something that's very clear. Yeah.
So there's similar concerns in the U.S. as well, and we see that, for example, former President Trump, now candidate Trump, has been talking about imposing 100% tariffs on Chinese EVs, even if they are manufactured or finally assembled in Mexico. So they have the benefit of that North American trade pact. And it seems that there's an intention, though, that, or at least there's a potential that there may be some encouragement to manufacture in the U.S. in order to avoid some of those concerns. Is there anything similar in the EU where there's some benefit to moving some of the assembly or manufacturing there? For example, we do hear that there are some of the big Chinese EV manufacturers that are setting up in Hungary or in other parts of Eastern EU.
Yeah, I think generally speaking, when Tesla was setting up its business in Europe, also, the manufacturing took place in China and in Fremont in the US, and ultimately they developed a facility in Berlin-Brandenburg, and I think generally speaking, this has been quite burdensome for them because Germany is a very complicated market to do business, very regulated, very formal in their approach. So it's difficult, but I think the incentive there was more to be geographically diversified, and in an era in which geopolitical risks are increasing, it probably makes sense to diversify your production facilities also to a certain extent, because I'm not aware of any specific rules that the EU is intending to apply at this very moment. But at the same time, as I already mentioned, it's clearly a topic. So it definitely cannot be excluded. Also, as German manufacturers, they have a more and more difficult position and find it more and more difficult to compete, that measures like these will be taken in the future.
I was interested that Tesla set up their, was it European headquarters in Amsterdam?
Yeah.
What was the driver or the rationale for making that choice?
I think that's an interesting question. I think, first of all, Amsterdam is a services hub, so it has a very well-developed services sector with a very highly skilled labor force, internationally oriented city. And also, the Dutch market is interesting for fiscal purposes. So you can set up tax structures from here. And that's also been used by a lot of international companies.
Well, and I know, of course, that BUREN, sorry to interrupt, I note that BUREN is a law firm, but also has tax advisory as well. So that demonstrates the tax structuring aspects of the Netherlands and Amsterdam.
Yeah, absolutely. And we do advise Chinese clients on setting up their corporate structures from the Netherlands, also from Amsterdam specifically, obviously, but from the Netherlands in general. And that also obviously includes tax structuring.
But I also was interested to hear you say that some of the mass claims actually were brought in Dutch courts. So why are Dutch courts such an attractive venue for these mass claims?
Yeah, it's because I think they typically tend to accept the fact that they have something to say about a matter relatively quickly. So, for instance, if something happens in the Brazilian rainforest, just giving you an example here, but that company also has a Dutch subsidiary, then it can happen that, the Dutch courts accept that they can have something to say about the liability of this whole group of companies. So this makes it very attractive to initiate claims in the Netherlands. Also, as I mentioned, we have quite a well-developed professional services industry with professional players in the background collecting these claims, and that's all quite sophisticated. So I think those elements are at play.
Well, you started off the presentation talking about sales models, and we had some questions, and I have some questions about that. First of all, we do have some of our participants this evening, those who are listening or watching, who had participated in our Next Gen Lawyers training course. And we actually did go through the distinctions between distribution agreements or arrangements and sales agency. And I think everyone who's had that experience and been through that can see that in every industry, there are a lot of similar concepts as to the distinction between distribution and sales agency. But I was trying to understand how sales agency would actually work in respect of automotive sales, because I understand the distributor model or the dealer model, as we would say in the US, and I can understand the online direct-to-customer model. But I'm having a little bit of trouble understanding the agency model when if the end customer is actually a consumer rather than if it's B to C as opposed to B to B. So how common is it across Europe to adopt agency arrangements? Why are some of these legacy automakers thinking about moving to agency arrangements? Yeah. And is there really a successful example of agency sales models?
Yeah, that's again a great question, Robert. Thank you. I think it is very challenging to do this, and I think the reason, just to start at the end, is because at the end of the day, also legacy automakers, they want to ensure consistency in their pricing. And you have the consistency in the pricing of the physical sales, so in the brick and mortar stores, but also what they want to develop is at the same time a parallel e-commerce channel. And the sales prices in the physical stores and at the e-commerce channel should ideally also be the same. And because you cannot, in a distribution model, say, okay, all my distributors need to apply a certain price level, it becomes very difficult to implement in a distribution model. So this is why, theoretically speaking, an agency model can also be considered and interesting. However, I think you correctly point out that it's quite difficult in an automotive sector to effectively change from distribution to an agency model, because all these distributors, they're used to the way things go. They buy cars, they have an inventory of cars, and they basically resell those cars. And they also take care of the after-sales activities. And agency is a completely different way of approaching that, because you cannot have your own inventory. You cannot have a high amount of people performing the after-sales activities. You cannot take over the economic risk of these transactions, and that's what they historically always have been doing. That's why I also pointed out in the presentation that I think it's possible to adopt an agency model from the offset. So just to start off by doing that, but to transition from a distribution model to an agency model has proven very difficult. And we've seen that with Ford, but we've also seen that with a number of other OEMs such as Stellantis and other OEMs who had the ambition of transitioning to an agency model for the reasons that I mentioned, but ultimately ended up shelving those ideas. Yeah.
So is there a successful example of an agency model in this automotive sector?
Yeah, I think Ford has tried to do this, but they have not succeeded as far. Yeah, I mean, I think they're still somewhat trying in the Netherlands, but they're not rolling it out internationally. So I don't think so, honestly.
Yeah, that's what intrigued me, because it seems inconsistent with typical market practice to adopt this agency. I understand exactly what you're saying in terms of maintaining price consistency, and yet you cannot do that through the traditional dealer or distributor model. But then the whole concept of agency, sales agency in this industry sector seems counterintuitive to me. So that's why I was interested.
And it's also risky to become to be very aggressive and to try to find things that you call agency but are actually distribution, because once you start implementing things that are actually distribution, then your agreement just gets requalified, and then you're really on the hook for these competition-related rules and potentially penalties. So, yeah, it's really, you need to thread very carefully if you want to do that. So yeah, if you start out, then I think you have a bit more flexibility because you are not bound by your previous relationships, and you can restructure them from the start. So I think that to a certain extent makes it easier. But I do agree that distribution and direct to consumer sales are probably the more typical choices, I would say.
Now, there was a technical point you brought up that I wanted to underscore, and I was glad you raised it because this is certainly a position that I've taken over the course of my career. And you mentioned the Convention on the International Sale of Goods and that you always want to exclude it. That's certainly my position, but I would like to invite you to share just a minute or two of an explanation from your perspective. Why do you want to exclude the CISG?
Yeah, there are a number of reasons for that, but at the end of the day, what you're basically doing is you're incorporating an entire set of rules related to your relationship, and it's in principle it does just apply when you sell goods internationally, and parties are typically not aware of the contents of those rules. So that in and of itself, I think, makes it very appropriate to exclude them, because you just want to be in control of what you agree to. And I think that's the primary reason, from my perspective.
And it does seem to be very pro-consumer.
Yeah, absolutely. Yeah.
Yeah. And that's exactly to your point. As the manufacturer, you want to understand exactly what your obligations are and not have to go and make reference to something that is much broader than you wish to accept.
Yeah. Yeah.
So that was a technical point. Now, there was another point about the litigation risks or the investigation risks. I was glad you made reference to the VW case, because it seems that there's a parallel there with what VW did with the diesel mileage and some of these other claims now for new energy vehicles. It's going to be, I'm sorry, I'm going to not use the correct term, but it's the distance of the how far you can go on one charge, et cetera.
Yeah.
And it seems to me that we have a lot of these similar concepts from legacy automotive business to the new energy automotive business. So are there other things that are consistent between legacy automotive business and new energy? And are there some things that are really unique to new energy automotive?
Yeah, I think, again, this is a great point, Robert. I think, you also had a lot of litigation with regard to internal combustion engine vehicles in relation to range. Because also there, for instance, the fuel usage and previously the range, was also determined under, basically benchmark conditions. So the vehicle was put on a belt to test its performance in those elements, and I think it was generally appreciated by the market that the vehicle's actual range was different than its benchmark range for internal combustion engine vehicles. And I would argue that the same holds true for EVs. But what you see in case law in the Netherlands, but also in other markets, is that courts, they sometimes take a different view, and they need to be educated on what these benchmarks actually mean. And I think it's very important, and makes your life a lot easier if you can show the court that not only are you educating them, but you've also already educated your customer. That just gives you an additional argument to say, listen, yes, the actual range is not the benchmark range, but we've also explained this to our customer. And there's no better alternative than a benchmark range, because a benchmark can at least be used to compare all these various electric vehicles. And what is the alternative to using a benchmark? It does not exist, right? So, I'm not sure if I totally answered your question with this, but I do think there are definitely a lot of parallels, but also the way it's been treated so far, in my view, is not very satisfactory by the courts. And they need some good guidance, and manufacturers, they just need to make sure that they do everything correct on their sides.
You also mentioned the risk of dawn raids, where they can just come unannounced and ask you to produce all of this information. One thing that occurred to me, well, two things. One is that I'm concerned that Chinese companies, not just in this industry sector, but perhaps in many different industry sectors, are not always as well prepared to respond to administrative investigations or to litigation, and don't have everything organized in that way, and don't have the team prepared internally and with external advisors to be able to respond adequately. That's one point, and I like your observation on that. But the second point is that I'm expecting, based on what you said, particularly with Dutch courts, that they will feel that they have the right, in fact, maybe this is the common approach, that they will ask not only for information that's based in the Netherlands, but actually may be back in China where the manufacturing occurred. And there may be some interesting issues in terms of getting access to that information. I'm just wondering if you can comment on any of those observations and scenarios.
Yeah, so absolutely. I think the first item is, I think it is challenging typically to prepare the information in a timely manner. So it makes sense to establish a communication line with an authority to explain what you can and cannot do, and to try to set some expectations on the time frame. So you need to devise basically a procedural framework. And I think what works really well in that respect is that you involve outside counsel who can effectively liaise with these counterparties and set the correct expectations. And sometimes they will still try to push you, and that definitely happens. And they will be unreasonable from time to time, and then you just do what you can, and they will have follow-up questions. That's the general experience. And it's not only the case that it's difficult, that these demands can be difficult for Chinese companies. I can tell you from experience that they can also be quite difficult for American companies, for instance. So they're always quite difficult. You just need to scramble and see what you can do. But at the same time, I think it is just generally recommendable to have outside counsel involved there, set up a project team that can manage that with clear responsibilities. Someone ideally in Europe managing it from an internal company perspective, and also someone abroad who can do the technical input, just depending also on the scope of the investigation. So, at Tesla, we typically also had our US engineers involved, and they submitted the technical input that we needed from time to time. And we also had European engineers, but very often we had late calls with the US and got their input on things. And that's just how those things go. Yeah.
Well, I'm going to jump back to the CISG question, because we had someone submit a specific question about that. Well, is there a better alternative to CISG? I would suggest that the risk with CISG is you don't exclude it, because if you don't exclude it, then it's going to apply because the member states are represented, and therefore they're parties to that convention, and therefore it applies. So what we're saying is you want to expressly exclude it and rely on local, either the governing law of your contract, local applicable law, and then, of course, the terms of the contract. What else would you say in response to that?
No, honestly, I couldn't have said it any better myself, Robert. I think what you want is to be in control of the contents of your agreement, and you can just specifically stipulate what you want to agree to in your agreement itself and exclude the CISG. And also indeed rely upon the statutory provisions that are already in place. So, I agree with that.
We had another question. whether EU officials or litigants might or regulators might try to implement stricter IP protection measures. Would that be another risk factor for Chinese EV OEMs?
No, they're not going to do that, I think, in a discriminatory way. And I think, European IP law is pretty well crystallized, so what you can and cannot do. So I do not really expect a lot of developments in that specific field. What you can expect is that, and the EU is very active in introducing all kinds of data protection related laws. So you have the Data Act, Data Governance Act. You have the GDPR, obviously. You have the AI Act coming up. Yes. So you have a lot of rules related to that. IP, I think, is pretty crystallized, and I do not see any big developments on the horizon there.
I thought it was really important that you mentioned the different types of data that is now being collected and accessed by these new automobiles. And I think that would be true for ICE as well as for these EV automobiles, because all of the video, all of the sensor data, all of the other interactions, the settings, whatever, there could be a lot of different things. Oh, and location data was actually probably the most sensitive. I think that is a very complex and complicating aspect, I would say, in the automotive industry.
Yeah, that's absolutely true. And as I mentioned also during the presentation, once you start selling cars at scale, you'll be receiving a lot of requests from authorities. Can you share data with us? And then you have to explain to them, what kind of data are we even collecting? And you need to think about that. What do you want to convey in those what do you actually want to be collecting? Because you cannot be collecting more than you need to collect, right? Then you're also in violation of GDPR. So you need to think about that.
Right.
I think with Tesla, we always, there was no location data being collected. So that was one of the most typical requests, because if a criminal is driving a vehicle, you want to know where it is, right? And then the answer was always, Tesla does not transmit location data from the vehicle to its servers, so we cannot share that information. And then video was only collected if there was a safety critical incident. But it makes sense to have a good overview of what you're actually collecting, and also have good responses for when you're actually getting those requests, because you will be getting them. I can tell you that.
At Tesla, you were in a pretty interesting situation, because wasn't there a significant percentage of the Tesla vehicles that were actually manufactured in China? And were you therefore subject to the possible risks of these investigations for anti-subsidy investigations or other measures that might be seen as somewhat punitive for Chinese manufactured EVs?
I think nowadays, I think most of the Tesla fleet that is sold in Europe is produced in the Gigafactory Berlin. But it used to be the case indeed that those I think Model 3s and also Model Ys were built in China. But that was preceding this development, I think. So it was not really a concern at that particular time.
Now I have a last question from my own interest, and that is, you obviously were a very experienced, highly skilled General Counsel for Tesla and Benelux countries. But how did you work with outside counsel? When did you have to go outside? It's a classic question for the in-house counsel, make versus buy. When do you do it in-house, and when did you go outside to seek advice? Because now you're on the other side, and obviously you will have a different perspective now. But when you were working inside at Tesla, how did you use outside counsel?
Yeah, it kind of depends, I guess. This is a very lawyerish answer, but Tesla had a very lean legal team, and therefore there was actually a need to involve outside counsel a lot. And the real challenge there was to identify the outside counsel who would be able to help you in a very pragmatic way, because you do not want a very elaborate response with all kinds of legal references, but not a real advice on what you're actually asking, right? So that was a real challenge to identify the person you need to have in each market. And that was actually a big part of my work to identify these people. But I think that the items that I discussed today, and this is also partially why I identified these items, are items that I would refer to outside counsel. I think you should not want to develop your own e-commerce platform without liaising with outside counsel, because I think that's very risky. I think it makes sense to liaise with outside counsel on actually the choice of your sales model. I think it makes sense to involve outside counsel when you are facing any kind of regulatory investigation. And I think it makes sense to liaise with outside counsel when you're facing litigation or even very difficult customers. I think it makes sense because sometimes customers just need to hear from someone outside of your organization that they need to seek some trouble elsewhere, right? So I think, those types of activities I would typically try to refer to outside counsel. And also there's just more, I think, overarching compliance-related matters, such as I mentioned, how you handle data, specific automotive-related compliance topics, such as homologation and stuff like that. So, and what do you do yourself? That's an also, I think, partially this question. Well, what I sometimes notice is when you, for instance, prep your lawyers for instance, litigation, that they need to be convinced about your position, about your strategy, about how your company is structured, and that you actually have a valid position. And also in negotiations, like how much risk are you willing to take? I think any company-specific input that will obviously need to, and strategic input, by the way, will obviously also need to come from in-house lawyers. I think they have a very important role there.
Yes. Well, I do have one last question. And that is, do you see any patterns of common mistakes that Chinese EV manufacturers may be making in the European market or in your jurisdictions in particular?
Yeah, I think there are still, like, I already reviewed like a lot of materials. Also, for instance, literally the websites that companies are using to sell their products. And my general impression is that they are not always 100% compliant, and they are generally pretty good, but they're not 100% compliant, and you need to be 100% compliant with these things. And if you're not, that's going to bite you. So that's, I think, definitely something that they should pay attention to. And apart from that, I cannot really see what's really happening underneath the hood, right? So, right. But I can see the optics, and that's a point for concern, I think.
Now, I noticed in your presentation there were a couple of places where you referred to memoranda that the BUREN firm has prepared. And is that something that we can make available to our audience?
Yeah, absolutely. I would be happy to share both these slides, obviously, of course, but also the materials to which these slides reference. That's absolutely.
Okay, I'm sure that would be most welcome. This has been a great presentation, a good conversation. I had some of my own questions, but actually the vast majority of the questions came from our audience members who were obviously listening keenly and have very keen interest in this market. I do think that the U.S. is problematic for a lot of reasons for Chinese EV manufacturers. The EU is not easy, but it seems to be more accessible.
Yeah.
And it's a very, very important market. So we really appreciate your sharing your insights. And we hope we have other opportunities to have conversations like this with you and your colleagues at BUREN. So thank you very much.
Thank you, Robert. It was my pleasure to be here.
All right. Good night to all. We'll see you next time.
Good night.